Goedendag allemaal en leuk dat jullie kijken naar de update internationale sancties tegen Rusland en Wit-Rusland van Nederland Distributieland samen met Greenberg Traurig. Een update is geen webinar, dat weten we inmiddels. Het gaat allemaal razendsnel. Binnen het half uur ben je helemaal bijgepraat. Heb je vragen? Stel ze dan vooral in de chat. En dan komt Erik of Cara daarop terug. En dan geef ik het woord heel graag aan Erik de Bie en Cara Bombach van Greenberg Traurig.
Good morning, everybody. Morning, everyone. Thank you, Joachim, for the introduction, and great to be here to do a presentation or a brief update this morning on the international sanctions on Russia and Belarus. I'm here together with Cara. We are both in Amsterdam, in the Amsterdam office of Greenberg Traurig. Cara is working in our DC office in the US and is also a specialist on international sanctions. And maybe Cara, you can do a brief introduction of yourself.
Of course, I'm happy to meet with all of you. We thought it might be interesting today to introduce maybe some different angles to the sanctions topic, in particular how not just the EU regulations, but US jurisdiction and US enforcement might be an issue for logistics, particularly here in the Netherlands. So thanks very much for your time.
Okay. My name is Erik de Bie. I work in the Amsterdam office of Greenberg Traurig, and I am a specialist in trade, customs, and VAT matters. So what we are going to do is to have a brief presentation and a quick update on the sanctions on Russia and Belarus. We're trying to share the screen now. What we will do is, thank you. It's not working as planned, but maybe to give you a quick update on the agenda. First, we will start with a quick update on the sanctions in the EU. That is, in the meantime, the EU implemented the 6th package of sanctions. Then, as a next topic, how can and do the US sanctions and potentially also other sanctions apply in the EU on EU businesses? And thirdly, we have a few scenarios, and we would like, in the meantime, answer your questions during the update of today. It may be the case that we cannot answer all the questions you have, and maybe if you have any remaining questions at the end of the webinar, then maybe you can send an email to Joachim at NDL, or you can maybe also send us an email if you have any remaining questions. First of all, what kind of sanctions are we talking about? And you hear a lot about direct blocking and asset freezes, and that's taking place all the time. And there are hundreds of such sanctions and asset freezes applicable at the moment in the EU. You have a lot of financial sector sanctions and banking restrictions. So a number of banks are banned or are also banned from SWIFT. What you also see is import and export restrictions. And there are a lot of talks about that these days. Investment-related restrictions, restrictions in the energy sector, especially in the EU. That's a hot topic, and the oil ban from the Russian oil ban, and also all kind of restrictions in transport and aviation. So for the logistics sector, if you have a shipment from the EU to Russia, for example, what needs to be checked? What kind of sanctions could you be confronted with? First of all, I think it's important to check, is it a restricted export or import? In case of an export to Russia, is it allowed to supply the goods to Russia? Then also, the second step is to review whether any sanctions parties are involved. And thirdly, what's also important, I think, for all parties involved is whether the banks involved in the transaction or are involved in paying for the services are on any sanctions list, because otherwise the payments cannot be made. So that are three basic steps that need to, checks that need to be done every time a shipment is done to Russia or Belarus. Sorry, just to come back to the presentation.
And while you pull that up, I'll add a comment too. We've made this presentation very focused on the Russia-Belarus sanctions, because that's obviously kind of the hot topic on everyone's minds right now. But I think these recommendations that Eric has presented here really are applicable for compliance with any of the different sanctions regimes, and really best practices from a trade compliance standpoint. So that's sort of one of our themes as we're working with clients, is to make sure that that these practices are implemented across the board. Certainly more scrutiny is going to be right now from an enforcement perspective on the Russia-Belarus related transactions.
So when there's a supply to Russia, one of the first checks to be done is whether the products qualify as military, dual use, or other restricted supplies. For example, also luxury goods. In the EU, there's a huge list of products that qualify as luxury goods. For example, expensive TVs, expensive cars, all kind of food products, etc., etc. So it's a huge list, and also a list of products that could contribute to the enhancement of industrial capacities in Russia. There's also another a substantial list. And so we are talking about three lists of EU products, and then also a lot of other products that are restricted and that are mentioned in the applicable EU legislation. So it's a lot of checks to be done in order to review whether products are allowed to be exported to Russia at all. If that would be allowed, then the second question is any sanctioned party involved?
Erik, als ik even mag, mijn excuses dat ik even onderbreek, maar wij zien de presentatie niet zoals jij die zou presenteren op dit moment. We staan stil op slide 5. En ik krijg toch de indruk dat je al iets verder was.
Ja, dat klopt. Yeah, so maybe what we will do, because otherwise we will we have on slide sanctioned parties involved. Do you see it now, Jochem?
That would be slide 7.
Jochem, can you hear us? So maybe what we will do is we will send the PowerPoint after the presentation, after the webinar. So then maybe you can forward it to the participants, Jochem. So maybe to go back, so after checking whether the goods are allowed to be shipped to Russia, the next question is whether any sanctioned parties are involved. So as already mentioned, we have listed persons and entities, and also entities that are owned or controlled by sanctioned persons are not allowed to do any business with European companies. So it needs to be determined case by case, is any of the parties involved, are they on the sanctioned list, or are they controlled by a sanctioned party or not? And then the third topic, as already mentioned, is whether or not a bank is involved, a bank that is on the sanctions list. For example, Sberbank is in the meantime restricted to do business with EU businesses, so you cannot make any payments through Sberbank. So that's about the EU side. But what is also interesting to look at is whether any US sanctions could apply to when doing business from the EU. And so, for example, you're talking about the shipment of products from the EU to Russia, and so the products are in the EU. The logistics company is in the EU, the seller is in the EU, and still it's possible that US sanctions apply. So Kara, maybe can you explain how that's possible? Huh?
Sure. So, and I'm not sure if the slides are keeping up, but generally from a jurisdictional standpoint, the US sanctions apply to US persons. The definition of US persons can vary across different sanctions programs, but generally it means entities that are incorporated under the laws of the United States or any territory of the United States, as well as their non-US branches. Normally, it does not apply strictly to wholly foreign subsidiaries of US entities, but we'll talk about that in a little bit more detail. The jurisdiction also applies to anyone physically located in the United States. So even non-US persons, when they are in the United States and take decisions that might violate or actions that might violate the US sanctions, that is within enforcement jurisdiction for US enforcement agencies. And then the sanctions also apply to US citizens or lawful permanent residents wherever they might be located in the world, and regardless of the nationality of their employer. So that can be a risk both for corporations, but also for individual employees or managers or board members. And then there's also this sort of extraterritorial reach where the jurisdiction is not over an entity or a person, but over a particular transaction. So for kind of a classic case of where a transaction becomes subject to US jurisdiction is if a wholly offshore transaction between non-US party and non-US party is actually a US dollar denominated payment. For a fraction of a second, that dollar denominated payment clears through the US financial system. And that's enough of a hook for US enforcement agencies to say the entire transaction is subject to US jurisdiction. So it doesn't make all of the conduct that those parties are doing everywhere around the world subject to US jurisdiction, but it does bring that transaction and potentially even related transactions into scope for enforcement actions. And some of the things I like to highlight for our non-US clients or multinationals that we're working with who have both entities in the EU or elsewhere, and then in the United States as well, is that even non-US entities are at risk of US sanctions enforcement actions. And the main agency that we're concerned with here is the Office of Foreign Assets Control, or OFAC. And so, it's very much, when it comes to sanctions violations, it's really a strict liability standard. And so what that means is that it doesn't, it really doesn't matter whether someone intended to violate the sanctions. It's purely a form of if the regulations are violated, if the word and the letter of the law is violated, and intent or sort of knowledge becomes relevant when we're talking about what kind of penalties might be assessed or mitigating the penalties. And so part of what that leads to is even non-US companies having to manage and deal with potential enforcement actions, like receiving or responding to administrative subpoenas. Potentially there's a risk, if you have a counterparty or a business partner who suspects that some transaction they have been involved in violated the US sanctions, and they decide to submit a voluntary self-disclosure. If one of your, if your business is involved somehow in that supply chain or that particular transaction, in the narrative of a disclosure, they would describe everybody who's involved. And so there is a risk that you sort of get, roped in to a narrative in an enforcement action that's actually disclosed by someone else. And then that can lead to direct questions or inquiries from the regulators and the enforcement agencies. And I mentioned before the issue where you could have wholly offshore activities, but particular transactions that come in scope for US jurisdiction. The other thing to think about is that there is a risk of secondary sanctions under many of the sanctions programs for non-US entities who are determined by the US government to provide material support or assistance to a sanctioned person or entity. And the result there, rather than an enforcement action with some sort of civil penalties case, would be actually having the non-US entity added to OFAC's sanctions list, which is not a place that anyone wants to be, because even though OFAC says, this is limited and narrow, it's a blocking order in the United States, it's not meant to be punitive. The reality is that once someone is added to the OFAC list, it becomes a global blocking, because most jurisdictions, most financial institutions around the world are going to screen the OFAC lists. And if they have a customer or a counterparty that is on the OFAC list, really it sort of becomes radioactive, and they're not going to want to deal with them, even if they're permitted to under their local laws or not, or they're outside US jurisdiction. A couple of quick notes here, also on the export control piece. Eric mentioned from the EU side, the EU export and import restrictions, and we have similar on the US side. I think one of the complications that we're all dealing with right now in this landscape of Russia, Belarus, is that the different jurisdictions like the EU, US, UK, Canada are all sort of moving in the same direction with sanctions on Russia and Belarus, but the measures are not the same. The measures are inconsistent, and the list of sanctioned persons or parties or controlled items to Russia are not identical across those jurisdictions. So that adds some complexity on the compliance side. But something to think about from the US export controls is that the jurisdiction doesn't apply over the people handling the US origin items or foreign made items with US content. Jurisdiction for US export controls applies to the items as they move around the world. So that includes goods, software, and technology that are US origin or foreign made that have de minimis US content. And so again, you could have a wholly non-US transaction, not even any financial element of it that would come in scope for US jurisdiction. But if you have US origin items, then you could potentially have export control issues. I just wanted to mention quickly, two recent, these are OFAC enforcement cases, not export control enforcement cases in the shipping and logistics industry that I thought were interesting and recent. So we have the Toll Holdings limited case, which resulted in a $6 million civil penalty settlement, and then Eagle Shipping. And Toll Holdings actually is an entirely Australian Melbourne-based logistics company. And then in the case of Eagle, Eagle is, I believe they are incorporated outside the United States, but they had a headquarters in Connecticut. But these particular cases had to do with logistics and shipping arrangements that were completely outside the United States. In the case of toll, the activities had nothing to do with the United States except they were processing payments in US dollars that for shipments and deliveries that had to do with countries that were, or individuals or entities that were the target of US sanctions. And Eagle Shipping was sort of an interesting situation because there they had deliveries primarily between, I believe it was Singapore and Burma. So again, sort of entirely outside the United States, but there were some elements here where they knew that they needed a license from OFAC because the parties in Burma were subject to sanctions. And the company actually sought OFAC licenses, but didn't wait for the answer. So it was like they acknowledged and recognized they needed OFAC permission, but they didn't wait for the permission. And then what's worse is that they actually got a denial letter from OFAC and continued to engage in the conduct. So that's fairly egregious, but I think one of the notes that's useful from that is that in the civil penalties notice, OFAC specifically says, and this I don't think will come to us as a surprise to anyone on the webinar, that the shipping and logistics industries are high-risk industries from a sanctions compliance standpoint. And so what that means to me, and why I thought it was important to reinforce to all of you, is that if it's in the OFAC enforcement division awareness and perception that you're operating in a high-risk industry, there's going to be more scrutiny necessarily on your activities. And so all the more reason to have really strong compliance programs and policies and procedures.
And then maybe the question is also, hey, you have companies doing trading in products, so exporting, importing, and you also have logistic service providers, so companies facilitating the transport, organizing the transport, etc. Maybe we have two examples just to briefly discuss. Also, I think both from a US and from an EU perspective. Just as a scenario one, and maybe Kara, you can also provide your input from a US perspective. And let's assume there's a shipment of tires that's in a Rotterdam warehouse, for example, that are pretty large tires that could be used for trucks. And this shipment is going to be with the destination to Turkey. And your principal asks you, logistics service provider, can you please ship the products to organize the transport to Turkey? But there's a reasonable chance, or it is, these tires can also be used for military use, maybe for trucks. And the impression is, both by the principal has the impression, but also the logistics service provider, that the tires, maybe the final destination will be in Russia instead of Turkey. So the question is, can you then proceed with such a shipment? Is it allowed to make the shipment? Because in principle, there are no sanctions on Turkey. You can make any shipments to Turkey if that's a request by your principal. And let's assume there are no sanctioned parties involved in the transaction. From a US perspective, Kara, even if the shipment is within the EU, it's going to Russia, would that be allowed? Would that be a problem from a US perspective?
You know, so what I would be thinking about here would be whether the European-made items actually have US content. So, and whether the items would be controlled under US export control laws to Russia. And under the sort of enhanced, expanded export controls over the last couple of months relative to Russia and Belarus, the list of items that are controlled or would trigger a licensing requirement it's extremely extensive. It's very, very inclusive of most items that are enumerated in the Commerce Control List, which is the positive list of items controlled for various reasons to different countries around the world. So that would be sort of my first piece, would be, do we have your de minimis US content, and then are the items actually subject to US export controls or controlled there? And I think then from the sanctions perspective, we've already, well, I would want to check in Eric's scenario, he said that there are no sanctioned persons involved in the transaction, but I would say make sure that you're checking the US lists as well, because we know, like we mentioned earlier, the EU lists and the US lists aren't identical, just to see what kind of risk there might be from a US perspective, if there are any parties or banks or anything that are subject to US sanctions.
Yeah, and from an EU perspective, I think if the party involved in the transaction or organizing the transport are aware or believe there's a chance that the goods are destined for Russia, there's a risk that this will be considered so-called circumvention. So that the authorities will conclude that everyone knew or should have known that the products are destined for Russia. If the tires are potentially used for military use, then there's a reasonable chance it's circumvention. The export is prohibited, and it's also not allowed to make the shipment to Turkey. And also under the EU rules and also under the rules of the member states, such transports are a violation of applicable law, both the sanctions legislation, but also fall under the national criminal legislation in the EU. So I think the party involved in the transaction, including the transport company being aware or should have been aware of a potential circumvention, can be punished, can be penalized by the authorities in relevant EU member states. So it's very important to consider both are the products and is the shipment prohibited, but also consider circumvention, a chance that products will end in Russia instead of in this case in Turkey.
Yeah, and if I can add there, just to pile on there, one more concept in the U.S. sanctions that could be relevant here is in case the European logistics company has U.S. person, management, or decision makers sort of in the business line that is doing this work, there is a risk for the U.S. Employees or U.S. Management who are working on this. We have a concept called facilitation, which essentially means that under all the sanctions programs, U.S. people are prohibited from facilitating activities by non-U.S. persons that the U.S. person would not be allowed to do directly. So if sort of underlying this, there would be a sanctions violation, a U.S. sanctions violation, but it's otherwise a wholly non-U.S. Transaction. If there's a U.S. person involved in that and they're approving or giving instruction to proceed with this, there is liability there under the U.S. sanctions.
Okay, then we have one other scenario is that there's a US-based customer of a European logistics company, and the instruction is please supply the goods to a destination in Europe. And the recipient is a European company, and this European company, the customer is not sanctioned by the EU, so it's not on any of the EU list, but is sanctioned by the US authorities. So the question is, from an EU perspective, maybe there's no issue, and you can make the shipment and do the supply. But what would be the implications from a US perspective? Is it allowed?
Right. So here there's a lot of issues with this one. I mean, there's clearly issues for the US based customer. But when the European logistics company comes into the mix, to me, this reads like one of the examples we gave earlier, where there could be potentially a voluntary self-disclosure by someone in this transaction down the road, or if the US regulators find out about it, if it were to go forward, they would be asking questions of everyone involved in the transaction. And so I would say here there is risk for the European logistics company, particularly here, not just because the the transaction, we know we have a US person sort of at one end of this, but if the customer is paying the logistics company in US dollars, now those individual transactions are coming into US jurisdiction, and that's going to be very difficult for the European logistics company to challenge from a jurisdictional standpoint.
Okay. So key takeaways. And so what is a complication globally is that the sanctions are changing rapidly, and there is a lot of coordination between the US, UK, and the EU, but things are still not, for example, the lists are not all the same. So, for example, you have persons who are on the list in the US, but not in the UK and the EU, and the other way around. What's also recommended is to have a very proactive approach. Consider the legal implications of violating the sanction, but also, for example, reputational considerations are recommended. And also, for example, what we have in the EU, we have the whistleblower program. So you can, companies are invited to report to the EU if they are aware of any violation of the sanctions. So it is important to be careful, consider the legal implications of non-compliance, but also other aspects. And as mentioned lastly, is have to focus energy and resources, etc. Invest that to make sure that all the parties involved in the transactions are checked and that the diligence is done properly in order to make sure that you comply. Carol, you have any other?
The only other thing that I would add is from a U.S. enforcement perspective is that OFAC has published a few years ago their framework for best practices for sanctions compliance programs. And something I always like to tell non-U.S. clients and companies is that the framework expressly states that OFAC expects even entities and companies that are outside of U.S. jurisdiction to have an OFAC sanctions compliance program if there is a chance that they have transactions like those U.S. dollar denominated, or they're maybe transporting or involved in U.S. origin items, that they would have a compliance program to address those things. So, so just some food for thought as you're reviewing your existing compliance programs.
And as a logistics company, I think it's important to understand and to be aware of the compliance program of your principals. So to make sure that your customers are doing the necessary checks, and you can use that information. But that is still, even if your customers are doing the necessary reviews, and still as a logistics company, it's important to do your own diligence, because you cannot just rely on what your customers are doing. I don't know if there are any questions.
Yes, there are some questions. Now, actually, there's one question, and that's about scenario 1, I think, Eric. Which party is responsible for getting the right info on who the end user is? Actually, a pretty interesting question.
Yeah, I think to answer, I think as a logistics company, it's probably difficult to get this information. So I think, legally speaking, that's also what you can arrange with your customers as a logistics company. So request your customer and organize it in such a way that your customer is doing the necessary checks also on the final destination of the products. But if you have any doubt as a service provider, I think you still have an obligation to do your own check. And if you continue to have doubts, I think the best decision is not to make the shipment. But in principle, and that's also what can be arranged in contracts with the customer, is that it's the customer's responsibility, and I think not the logistics service provider.
Yeah.
But there's no excuse. So especially with sanctions, you cannot say, I was hoping or thinking that my customer was doing the necessary checks, so I relied on that, and so I have no responsibility. That's not how it works, not in the relationship with the authorities. Carol?
Yeah, no, it's the same. It's the same from the US. And I would say, right, you can't completely put everything on the customer, but certainly emphasize with them that you are expecting that they're doing full checks and get commitments from them for that. And to Eric's point, it won't work to ignore red flags. That was actually one of the facts in one of the enforcement cases that I put on the bullets there. They had information that I think it was in the shipping instructions that the originator of the shipment was someone who was subject to sanctions, and they went back and asked questions, and the customer revised the documents and sent it back without the sanctioned person on the document, but then nothing else in the transaction changed. And then later they learned some more information that it seemed like the shipments were still coming from that sanctioned person, and yet they continued to do it. So that just sort of piles on the bad facts.
Great, thank you so much. No, there's another question actually, but when it comes to potential sanction charges, the logistic service provider should have some kind of proof. That will be difficult, right?
The proof of, I'm not sure I understand the question exactly.
But when it comes to potential sanction charges, the logistic service provider should have some kind of proof. And that's difficult for parts. That's what the question is. But it's maybe not a question, just a statement.
Yeah.
So I'm also do not fully understand the question, to be honest. But so if there's maybe maybe it's an idea to send in the question by email and to clarify, and then we can maybe provide some.
Yeah. Great idea. So please show us the next slide. It's all on here, right? Your email addresses. Thank you, Kara. Thank you, Eric, for doing this nice little update. I'm now changing to Dutch again. We gaan de presentatie met jullie allemaal delen. Heb je nog vragen, mail of bel, e-mailadressen zie je hier ook in het scherm. Nogmaals veel dank aan Erik en Kara. En ik wens iedereen een fijne dag. Maak er wat van. En als je niet tevreden bent, doe er dan wat aan. Dag.